Hello, Chapter 8, Company Administration. This chapter is going to be looking at how companies operate, meetings, that sort of thing, directors, how they're agents of the company. Questions predominantly in this area are knowledge based, so it's important that you become familiar with the main provisions relating to those seen as being the officers of the company, namely directors, company secretaries, auditors, how they operate and their rules and regulations governing how they operate. Remember that directors and company secretaries would normally be seen as agents for the company, so the agency laws we looked at earlier may apply in any question. So far as the company's auditors are concerned, you do not need to consider any audit procedures. You'll get that later in paper F8, but you simply need to know how they're appointed, how they are removed. Can auditors resign? Well, yes, and their rights and duties as auditors. Questions, particularly perhaps relating to directors, may be put in the context of corporate governance considerations, which is, paper P1, but it can also appear here. Key knowledge, directors. Key number is private companies only need to have one. Public company needs to have a minimum of 2. You can have as many as you want. Age requirements 16. Qualifications. You may be surprised, but there are no formal qualifications required in law. So anybody can be a director in terms of qualifications. Having said that, you can be disqualified. These can be for under the Companies Act, if you become bankrupt or make an arrangement with any creditor, you become insane, you're absent without consent for a period of 3 consecutive months from board meetings, and the other directors determine that they should get rid of you, they give written notice of your resignation. Okay. Under the provisions of the Company Directors Disqualification Act, an individual may be disqualified by the court on the following grounds for up to 15 years. Persistently in breach of company legislation, involvement in fraudulent trading deemed to be in the public interest, participation in wrongful trading, involvement in certain competition violations, conviction relating to company promotion, formation, management or liquidation. Under the CDA, court must make disqualification order for a minimum of 2 years if satisfied director of an insolvent company or deemed unfit for company management. Please note there are various terms used to describe directors, and that somebody may in law be regarded as a director even if they have not formally been appointed as such. The key terms are an executive director. This is someone who's usually full-time working for the business and involved with the day-to-day management of the company. Non-executive directors, however, are part-time. They're involved with the company's corporate governance procedures rather than the specific day-to-day management of the business. They should be seen to be independent. Managing Director, also known as the CEO, Chief Executive Officer, they have greater implied powers and have overall responsibility for the executive management of the company. A Shadow Director, not formally appointed as a company director at all, but board commonly follows their request, so they are around in the background, hence the shadow description. Alternate director, in effect, is a replacement for another director being enforced periods of absence, usually for illness. Appointment of directors. Details of the company's first directors are provided as part of the registration process, as we looked at earlier. It is the company's articles which lay down the rules relating to the directors, but normally subsequent appointments may be made by the board, by the company in a general meeting. Notice it's an ordinary, not special resolution. Retirement, re-election of directors. Well, under the model articles, first AGM all retire if it's a PLC, but they can stand for re-election. Subsequent AGMs, nearest third should retire, but may stand for re-election. Publicity regarding directors. The main points to note are as follows. Details of directors and any changes must be filed with the Register of Companies. Details must be maintained in the Register of Directors. Copies of directors' service contracts must be available for inspection. Listed companies must produce the directors' remuneration report as part of their annual accounts. Removal of directors. The main points to note are as follows. Special notice, not ordinary, so 28 days, not 21, must be given to company of a resolution. Copy of resolution must be given by company to a director. The director has the right, at the company's expense, to make it reasonable length representations before the meeting. The director also has a right at the meeting to address members before a vote takes place. Removal requires passing of an ordinary resolution. Removed director may be entitled to compensation for loss of office. Duties of directors. Companies Act has codified 7 general duties. These are listed on the screen. I don't think I'm going to go through them because they're hopefully fairly self-explanatory. Powers of the directors. Generally, the powers of the director will be outlined in the company's articles, but you should also remember the general rules of agency law with regard to directors, so that they have both actual authority, which is expressly or implied, and they have ostensible authority, i.e. the fact that they're a director, they're ostensibly in charge. Company secretary. All private companies are not required to have a company secretary. However, all PLCs must have a company secretary, who should also be suitably qualified, either on the grounds of experience or through the holding of a recognised professional qualification. The duties of the company secretary are very important because that is who the company is identified by. So, anybody wants to write to a company, it's the company secretary who you write to. They must keep statutory books, organise and minute board meetings, organise and minute company meetings, ensure proper accounting records are maintained, financial statements are properly prepared, filing company accounts returns done on time, and sign the company documents as required by law. You could have a question that just simply asks for that in the exam. Not difficult to learn, maybe harder to remember. Auditors. Appointment of auditors is done by members at the AGM. Initial appointment probably done by the directors, and it also may happen to fill a casual vacancy, i.e. the incumbent has resigned. What does the rights of auditors entail? First and foremost, they have access to all company books, records at all times. Auditors doing a statutory audit cannot be denied something they ask for. They can also obtain all information and explanations considered necessary in doing their audit. They can receive notice of, to attend and be heard of at a general meeting regarding the financial statements. Should they want to resign and can request directors to convene a general meeting where there are surrounding circumstances which they would like to bring to people's attention. They are entitled to make representations to shareholders where there is an attempt to remove them from office with which they do not concur. So it's not just a case of kicking the auditors out because you don't like what they've got to say. They're actually entitled to say what they want to say, should you want to kick them out. Duties of auditors. Under the Companies Act, main duties and responsibilities are to report the opinion to shareholders on the financial statements. Do they give a true and fair view? Have they been properly prepared in accordance with the Act? They must consider the implications for auditing on the financial statements. Are they consistent with other information that they've seen? Should things not be as they like, they can qualify their audit opinion where necessary. Should they really not like what they're doing, they can provide proper notice on resigning and resign. A concern here for auditors is they should not be able to just fade away quietly in order to avoid an awkward situation. So they should be able. Key points are that auditors must deposit formal written notice at the registered office. Such notice must be accompanied by a positive negative statement explaining the circumstances with which they find themselves. The auditors should request the director to convene a general meeting so that the members may have the opportunity of questioning the auditors further. The Companies Act provisions here follow closely the rules with regard to removal of directors considered earlier, i.e. special notice must be given of the resolution proposing a change in auditors. Auditors must be notified of this resolution, and if they wish to contest it, they have the right, at the company's expense, to pre-circularise, i.e. send out their representations to the members as to why they should stay in the office. At the meeting that's then held, they can again put forward their position before the vote takes place. Removal of an auditor will require the passing of an ordinary, i.e. a simple majority, not a special resolution, which is 75%. Do note these. Company meetings and resolutions. Well, the table is there in front of you. Don't propose to go through it now. Just watch 21 days, 14 days, special, ordinary. They're the key things to think about. Okay, there's your ordinary 51%, special 75%. That's your key. Okay, that's the end of that chapter. I hope that was helpful, and I'll see you in chapter 9.